Welcome back to Legal Brain. In today's class, I'm going to discuss about foreign antitrust regulators on combination. So this is an important area and exam point of view, in which I'm going to discuss about what do you mean by combination, how to regulate in different countries, like mainly the USA, the UK, then European Union and India. So I'm going to discuss about combinations today. So before discussing, what is the meaning of combination or what is combination? So in India, an Indian concept that is under Competition Act of 2002, Section 5 gives definition for combination. So combination meaning is acquisition of one or more enterprises by one or more persons, or merger or amalgamation of enterprises shall be a combination of such enterprises and persons or enterprises. So in simple words, combination is an umbrella term, and that can be a merger, an amalgamation, or a merger. So merger, acquisition, or amalgamation can be termed as a combination. So next is types of combination. The combination can be of three types. First one is horizontal combination, second is vertical combination, and third one is conglomerate combination. So I'm going to tell you what is that. So first one is horizontal combination. So horizontal combinations are formed between enterprises that operate in the same level of production process, and they are, substitute goods available for the same. So sometimes such a combination can be bad in law. So mainly horizontal combination happen at the same level of production process. Next is vertical combination, and vertical combination, they mainly happens wherein the firms are in different levels of supply and distribution of the product, like wholesalers, retailers, different levels, supply chain, different level. And the formation of vertical combination leads to pro-competitive environment in the market. And the third one is conglomerate combination, and this can involve enterprises of firms that are unrelated in the business fields. And it's purely like they are not related to each other and they form a merger or combination. A simple example is that if one company is involved in the production of goods while other company provides services for the same. So there can be a combination in such categories too. So these are the three different types of combination. So now I'm going to speak about how to regulate, or what are the foreign antitrust regulators on such combinations. So first, I'm going to discuss about the concept of the USA. In USA, how or which acts regulates combination. The first one is Sherman Antitrust Act of 1890, which is a very old act and which actually speaks about combination. So under this particular Sherman Antitrust Act of 1890, which is actually kind of vague and general, as the laws are dependent upon judicial interpretations in USA. So US Supreme Courts will give interpretations, or in different, it may vary from case to case. So, but in generally, under the Sherman Antitrust Act of 1819, pertaining to mergers and acquisitions under the ambit of combination, vary from case to case, as I've told you. And they are highly subjected to interpretation by the US Supreme Courts. So first one is the combination contracts and conspiracies which causes restraint in the market. And second one will be any conspiracies, monopolization, and conspiracies that attempt to monopolize. So these can be termed as anti-competitive practices falling under Sherman Antitrust Act of 1890. And there is a very landmark case, so very important. And first one is North Securities Company versus United States, and that is 1904 case, an old case. So in this case, the court in the US adopted that all the mergers formed between the firms who are in direct competition with each other shall be a restraint of trade, and it is a violative provision of Sherman Act. So they say that whenever there is a merger, so again, merger meaning is combination. So whenever there is a merger which is formed between the firms that are in direct competition with each other, leads to a restraint of trade. And also this decision by the court hindered the creation of new monopolies in the market in the form of horizontal mergers. The next one is Clayton Antitrust Act of 1914. So this is another act in the USA. So Clayton Antitrust Act mainly, this act prohibited price discriminations, mergers, and exclusive dealing in the market, which caused anti-competitive practices. And the monopolizing activities, which are condemned under Sherman Act of 1890, were specified and further extended under Clayton Antitrust Act of 1940. And there is another important case law, that is US versus General Dynamics US. So in this case, the Supreme Court rejected the review of antitrust regulators on the exclusivity of market share. And in this case, the court held that a merger history, structure, and the probable figure can be of significant use for determining the probable anti-competitive effect on the merger. So you have to look into the merger's history. That will help to identify whether there is anti-competitive practices or anti-competitive effect while doing a merger. The next one is Federal Trade Commission Act of 1975, yet another important act. And this particular act declares the unlawful method of competition or the unfair or deceptive, acts or practices that tend to affect the market. So under Section 5 of this particular act, they prohibits the unfair method of competition in the market while doing the, regulating the or doing the combinations. And furthermore, the Commission is empowered to take action against anti-competitive conduct, which is violative of the Clayton Antitrust Act of 1914 and also Sherman Act of 1890. And next one is Hart-Scott-Rodino Antitrust Improvement Act of 1975, and this is a very important act, and this particular act established a mandatory pre-merger notification procedure for the parties to a merger or combination. So this particular, this was a great change, and it caused a mandatory pre-merger notification. So in order to keep in check with that, and this act made it mandatory for all the parties to a merger or combination to notify the U.S. Justice Department and FTC before completing the transactions. And that was all about the USA. And now I'm going to discuss about the condition in European Union. So the first one is the European Community Merger Regulation, which is known as ECMR 2004. And based on this, the regulation introduced the term concentration in the market rather than the term merger. So this was done because concentration applies to mergers of two entities, as well as when there is a concentration which falls short of a full concentration. And there were no provision explicitly dealing with the mergers or combinations in European economic community, but they use the word concentration in the market. And next, I'm going to discuss about the condition in the United Kingdom. And as you all know, the Brexit, and also UK have came out of European Union. And the competition policy in the UK can be tracked from the Restrictive Trade Act of 1956. And also, in order to regulate the antitrust domestic laws, the Competition Act 1998 and also Enterprise Act 2002 were introduced in the United Kingdom. So first one is Competition Act of 1998. So based on this particular act, which is mainly based on Article 81 and 82 of the EC Treaty. And Chapter 1 of the Act, like the Article 81 of EC Treaty, prohibits the anti-competitive agreements and anti-competitive practices forming a cartel, abuse of dominant position, price fixing, and so on. And Chapter 2 of the Act, like Article 82 of EC Treaty, talks about the abuse of dominant position in the market, and the Director General of the Fair Trading and Competition Commission, which replaced the Monopolies and Mergers Commission. And next one is the Enterprise Act of 2002, yet another important act. And the Part 5 of the act deals with mergers and combination and regulate mergers and combination. And Part 4 and Part 5 of the act deal with market investigation and the regulating commissions. Also, the creation of relevant mergers is defined in Section 23 of this Enterprise Act. So these are the acts in the UK. Now, coming back to India, the procedure regarding the regulation of combination includes step 1 to notify. That means to notify the commission, that is Competition Commission of India, regarding the merger or, the combination that you're going to do as per the prescribed under Section 6, Subclause 2 of Competition Act of 2002. So the first step is to notify. The second one is to inspection of the notice. So once when CCA gets, a notification, CCA will carry out an inspection in accordance with the amendment regulations of 2016. And under 2016, we do have, amended to Section 6. So Section 6A speaks about a regulation in India. Regarding combination. So, however, if there are any defects found to be in merger or combinations, the parties to the combination are asked to remove such defects. Third one is Prima Facie opinion. So as per Section 29, Subclause 1 of the Competition Act of 2002, the Competition Commission of India needs to have a Prima Facie, opinion within 30 days of the receipt of the notice, and in accordance with 2016 amendment of the regulation that is based on Section 6A. The Commission may order the parties to the combination to file additional information regarding the combination. Further, the parties to the combination to a merger are asked to publish requisite details of the combination in accordance with Section 29 subclause 2, which creates an open invitation to the public to come forth with a statement of objection if the public is having any objection or any opinion. They can object it within 50 days from the publishing under Section 26 subclause 3. And another important provisions are Section 29 subclause 4 and 29 subclause 5. The Competition Commission of India reserves a right to demand additional information regarding the combinations or mergers under these sections. This is the procedure in India. The step 4 is that proceedings with regards to the final order. So Competition Commission of India, as per Section 31 of Competition Act, decides as to whether the combination will have an adverse effect in the market or not. That means, appreciable adverse effects on competition. So if at all, the commission finds that there was no adverse effect on the market, then the transaction will be approved under Section 31 subclause 1 of Competition Act of 2002. And if at all, if the findings of the competition state that the combination shall have an adverse effect, it will be declared the requisite transaction null and void, which is not enforceable in court as per Section 31 subclause 2 of the Competition Act. And also, there can be a third, case wherein the commission can provide the parties with a modification to be made in the transaction to curb out the provisions. Sometimes, there can be an illegality. So the commission can actually ask them to remove such, illegality from the combination, which have the potential to cause an adverse effects in the market. And this is done in compliance with Section 31 subclause 3 of Competition Act. So these are the concepts regarding combination types, and the foreign antitrust regulators. I have discussed about the concept and acts in the USA, the UK, European Union, and in India, and the procedures. This is an important area. I hope it's clear for you. If you do have any doubt, do comment below. Thank you for listening.